Hello friends. Today in a series of lecture on the governor, today we will be discussing the discretionary powers of the governor. The Constitution of India authorizes the governor to exercise some of his functions in his discretion. Article 163, Section 1 of the Indian Constitution ensures the discretionary powers of the governor. It is because of this discretionary jurisdiction that no amendment was made by the 42nd Amendment Act in Article 163, Section 1 of the Constitution. Now, what do we actually mean by the discretionary power of the governor? According to the Constitution, the governor is empowered to exercise some of his functions in his discretion. That is, he will not be required to act in accordance with the aid and advice of his Council of Ministers headed by the Chief Minister, or he may not seek for such advice at all. Article 163 expressly recognizes that there are areas in which the governor need not act in accordance with the aid of Council of his Ministers headed by the Chief Minister. Rather, he might act independently of the ministerial advice. There are two types of situation in which the governor is expected to use his power of discretion. These two types of situation are, firstly, those which are implied by the nature of parliamentary democracy and the Constitution, and secondly, those where the Constitution has expressly imposed special responsibility on the governor. Now let us see the discretionary powers of the governor as being enshrined in our Constitution. The functions which are specifically required by the Constitution to be exercised by the governor in his discretion are, firstly, Para 9, Section 2 of the 6th Schedule, which provides that the governor of Assam shall, in his discretion, determine the amount payable by the state of Assam to the District Council as royalty accruing from licenses for minerals. Secondly, Article 239, Section 2 of the Constitution, which authorizes the President to appoint the governor of a state as the administrator of an adjoining union territory, and provides that where a governor is so appointed shall exercise his functions as an administrator independently of his Council of Ministers. Besides these above two functions to be exercised by the governor in his discretion, there are certain other functions which he can exercise on his special responsibility. Now, functions on special responsibility as enshrined in the Constitution which has been granted to the governor are the following. Firstly, under Article 371, Section 2, the President may direct the governor of Maharashtra or Gujarat that they shall have a special responsibility for taking steps for the development of certain areas in the state such as Vidarbha, Saurashtra. Secondly, the governor of Nagaland shall, under Article 371A(1)(b), have responsibility with respect to law and order in that state so long as internal disturbances caused by the hostile Nagas in that state continue. Thirdly, Article 371C, Section 1, as inserted in the year 1971, empowers the President to direct the governor of Manipur that it will have special responsibility in securing the proper functioning of the Committee of the Legislative Assembly of the state, consisting of the members elected from the hill areas of that state. Finally, Article 371F(g), inserted by the Constitution 36th Amendment Act of 1975, imposes a special responsibility upon the governor of Sikkim for peace for an equitable arrangement for ensuring the social and economic advancement of different sections of the population of Sikkim. In the discharge of such special responsibility, the governor has to act in accordance with the discretion of the president, and subject to his discretion, the governor will act in his discretion. So these are basically the constitutional provisions so far as the discretionary powers of the governor is concerned. But there are certain other areas, or more specifically we can say that there are certain situations in which the governor might exercise his discretionary powers, and these situations or these powers are clearly not spelled out in the Constitution of India. Firstly, as an instance to this point, we may cite the report that is being prepared by the governor to be presented to the president under Article 356. According to this report, the governor may suggest that a situation has arisen in the state in which the government or the administration of the state government cannot be taken in accordance with the provision of the Constitution. Under such a situation, the governor may request the president to impose the emergency rules in the state under Article 356. And it is obvious that such a report will go against the existing ministry of the state legislature. So it is natural that such a report cannot be prepared by the governor with the aid and advice of his Council of Ministers. Thus, we can say that the Article 356 can be regarded as a function to be exercised by the governor in his discretion. Obviously, it must be noted at the same time that the governor is also a medium through which the union government keeps itself informed. Or rather, we can say the union government through the governor of the state actually gets information whether the state is complying with the directives issued by the union from time to time or not. Secondly, there are certain other matters in which the governor may exercise his power of discretion. One such matter can be the reservation of bail for consideration of the president. That is Article 200. Now, the governor may not always be in agreement with his Council of Ministers so far as the reservation of bail is concerned, particularly when a situation has arisen in which the governor belonging to a political party different from the party which has formed the ministry in the state. So, if he considers, however, his action of discretion is justified on the ground, if he considers the bill in question affects the power of the union or it contravenes any of the provisions of the Constitution. Now, discontentment regarding reservation of bills is not a new phenomena. It has a definite past examples. One such example can be cited in the year 1952 when Morarji Desai was the Chief Minister of Bombay. And he complained that the governor of the then state had actually sent the State's Essential Supplies Act to the president and then asking him to delay his assent as inappropriate, extraordinary, and would set a very awkward precedent. In fact, President Rajendra Prasad too commented unfavorably that during the years 1953 to 56, 1,114 out of 2,557 laws enacted by the state legislatures had come to him for his consideration. From 1977 to to November 1985, almost a similar number of bills were sent to the President for consideration, out of which all except 90 got the assent of the President. Sometimes even presidential assent on a state bill could benefit it. An example in this regard can be cited in the year 1950, when the presidential assent was thought to strengthen the validity of state zamindari abolition bill. Also, a state law having presidential assent might be more likely to survive court challenge, since it had already received the law ministry's approval during consideration. Thirdly, as S.R. Maheshwari observed, that governor sends to the President regular reports on the development of the state, and this report he makes independently of the ministerial advice. So in this way, it actually widens the discretionary powers of the governor. Fourthly, appointment of the chief minister happens to be one of the cases when, despite the electoral mandate, the governor might find himself in a situation in which he can exercise his discretion in response to a fluidity of a situation. This happens particularly in a case when, after the general election has proved to be a failure in throwing a clear-cut majority party in the state legislature, or there was absence of pre-poll alliances amongst the parties. In such a situation, the governor can use his discretionary power and take a sharp note on the appointment of the chief minister. The first use of governor's discretionary power came in Madras in 1952. In the first general election, it was found that the Congress party had won 152 seats out of the 375 seats in the legislature. But a united front government led by T. Prakasham gained 166 seats and claimed to form the government in the state. But the then congressman, the early congressman, the long-time congressman and the governor, Sri Prakasha, rejected Prakasham's claim and invited C. Rajagopalachari to form the government. It must be noted that C. Rajagopalachari was not even an elected member of the state legislature. So the governor of the state nominated him to the upper house of the state legislature, from which he was being elected as the Congress legislature party, thereby making him eligible to become the chief minister. However, C. Rajagopalachari had managed to gain the necessary majority seats when, after 16 members from the opposition crossed the floor and joined him. Another such instance can be noted in the year in 1971 in West Bengal, when the then governor, Mr. Dhawan, did not invite the CPIM leader, Mr. Jyoti Basu, to form the government, despite the fact that the party, along with others forming the United Front, had the majority, the required majority of the election. Fifthly, possibly more controversial than the appointment of the chief minister happens to be the dismissal of the chief minister and his council of ministers in a midway of a 5-year term of the Legislative Assembly due to the loss of majority in the House. Constitutionally, though the chief minister and his ministers hold the office during the pleasure of the governor, but in the terms of the parliamentary democracy, this pleasure has been reduced to mere gaining of majority support in the state legislature. Such a situation had occurred in the year 1967 in West Bengal, when the governor Dharamveera doubted the majority of the United Front government with Ajay Mukherjee as the chief minister and demanded for his resignation. When the Chief Minister decided or tried to act instead, Mr. Dharamveera recommended the imposition of the President's rule in the state. For more than 40 years, such discretionary powers was being enjoyed by the governors of the state in our country. But situation somewhat changed after the landmark judgment of the Supreme Court in the famous Bommai case. In S.R. Bommai and others versus Union of India in 1994, the Supreme Court held that any dispute on the loss of majority of a ministry in the Legislative Assembly would be resolved on the floor of the House only, thereby negating any possibility of the governor exercising discretion in assuming about the loss of majority support of incumbent ministry in the Legislative Assembly. Sixthly, again in the case of proroguing the session of the Assembly, the governor is placed in a situation to exercise his discretion. To illustrate, if in the middle of the session the Chief Minister asks the governor to prorogue the session of the House, fearing that he might lose his majority, or if no confidence motion is pending against the ministry, then the governor is justified in refusing to accede to the Chief Minister's advice and continuing with the session of the Assembly. The same logic perhaps is applicable to the dissolution of the Assembly as well. Seventhly, another subtle discretion to the governor seems to be available through the provisions under Article 175, Section 1 of the Constitution, which envisages that the governor can address either houses of the state legislature separately or together, in addition to delivering special lectures or special addresses to the commencement of the first session of a newly constituted assembly after fresh elections and the inaugural address in the budget session. Conventionally, such an address is being drafted by the Council of Ministers headed by the Chief Minister. So probably they might contain certain objectionable matters which the governor might find as politically unsavory and constitutionally improper. Hence the question arises whether the governor can refuse to read such an address prepared by the Council of Ministers. The opinion of the jurists in this regard converge on the point that the governor cannot outrightly refuse to read the address drafted by the Council of Ministers headed by the Chief Minister. Rather, he can avoid mouthing some parts of the speech which he finds as objectionable and contravenes the provisions of the Constitution. Finally, the governor also has discretion in seeking the information from the government on any aspect of the administration. Though the Chief Minister is bound to provide him with all the necessary details of the day-to-day administration, yet he might find that any issue which is not being clearly spelled out to him, then the information provided by the Chief Minister can be called for, and he might seek clarification regarding it. Moreover, the governor may ask the Chief Minister to place before the Council of Ministers for consideration any matter over which the decision has been taken by the minister without the consideration of the Council of Ministers. Thus, a thorough study of the governor's discretionary power suggests that it need to be codified to a certain extent, either in forms of law or through conventions. Suggestions for codifications have been made from time to time. Ashok Sen suggested the central and state government collaborate to devise a code of conduct. The Rajamannar Committee advocated amending the constitution to enable the president to issue instruments of instructions to governors concerning their relations with the central government and how they should act as head of the government, including in their exercise of discretionary powers. In fact, the absence of a well-established understanding of the limits of the discretionary powers as being enjoyed by the governors, there might be a situation in which personal prejudice and central interventions in the state's activities becomes a great controversial issue. In this respect, that Austin's remarks seem to be very interesting. Austin here rightly points out that unless governors conduct themselves strictly as constitutional monarchs, the office is likely to prejudice cooperative center-state relations and effective administration and risk the viability of the democratic constitution. So we see that if the discretionary powers are exercised by the governor, then there is a possibility that it might adversely affect the center-state relations. Along with it might prove to be a threat to the democratic setup of the country. Thank you.